I don't necessarily like this analogy, but we are more of the liquor store. You don't get to come in here without your parents.
Great. You don't like it? You do not have to read it. I promise. This is not assigned reading in your high school.
I feel like there are a lot of people who come into a library who might want to learn about something that they don't feel comfortable talking to a librarian and asking for.
My hope is that it's fought. I hate to say that I hope that Meridian or Boise or Coeur d'Alene carries the burden for us, but I hope the first $250 fine is one of the big libraries.
Well, there haven't been any $250 fines issued so far that we know of, but the burden of fighting Idaho's new library law is being carried by a few private schools, public libraries, parents, and churches from Boise and Sun Valley. A lawsuit with 11 plaintiffs has been filed in federal court against the state attorney general and the Ada and Blaine County prosecutors over Idaho's recently enacted Children's School and Library Protection Act. The law, in simplest terms, if someone finds a book in the children's section of a library, a book they consider obscene or harmful to children, they can file a complaint. The library then has 60 days to move it to an adult section, remove it entirely from the library, or face a fine of $250. The lawsuit alleges the new law is vague and also unconstitutional, and they want it to stop being enforced. This is something we've heard before, this unconstitutional and vague part, and it's led to a lot of different interpretations on how to handle it, as you just heard. For example, the Boise School District and Meridian Community Library, they have both decided to limit who can challenge a book on their shelves. Riggin schools, they put a parental policy in place where a child can either have all access, limited access, or no access to their 3 categories of middle school, nonfiction, and young adult materials. Other libraries, like in Idaho Falls, or as you just heard, in Donnelly's one-room library, they've opted to restrict where in the library kids are allowed to go without an adult, if at all. So here we are. Per the wishes of Donnelly's librarian, Sherry Shalene, the fight for all libraries has been taken to court. Joe Paris sat down with one of their lawyers.
A collection of complaints has Idaho's new library content law set for legal review. Labeled in a new lawsuit as an unprecedented attempt by the government to control speech and ideas in private institutions, plaintiffs want the new law thrown out on constitutional grounds.
We were looking at this law well before the governor signed it and have been kind of tracking it as it made its way through the legislature.
McKay Cunningham is on the legal roster for the group looking to get the law previously known as House Bill 710 taken off the books. Public schools and libraries have expressed concerns. This group, though, does include private schools, private libraries, and a church, just to name a few.
The definition that the legislature included for what is harmful to minors is incredibly broad. It's very vague.
From the perspective of the plaintiffs, they see clear constitutional and practical problems.
The point of the lawsuit is to ensure that materials that are scientifically, culturally, socially important, and that have historically enjoyed First Amendment protection continue to enjoy that protection in the state of Idaho. I should be clear that every single one of my clients, every single one of the plaintiffs in this lawsuit, they agree that minors should be shielded from obscene and pornographic materials. That's not the issue. The issue is that HB 710 goes way, way beyond that.
Libraries, like this public one in Donnelly, cite ambiguous language in the law as a concern. Donnelly, who's not a part of this lawsuit, avoided potential problems by simply rebranding themselves as an adult-only library.
Works of art that society has long deemed valuable, whether it's Michelangelo's David or an impressionist painting that maybe has a partially nude rendering of a human being, are all included, arguably, within this very broad definition of what is harmful to minors. And it may be that there is a challenge to Michelangelo's David, and it goes through the court system, and the court says, okay, this falls outside of the definition of harmful to minors. But all of that is still a harm to public libraries and private libraries and schools across Idaho, because you've got to be ready to defend.
The lawsuit also looks at inconsistency, or picking and choosing, in the law in terms of what is obscene or what is harmful material. For example, any act of homosexuality can be seen as obscene.
Why is it that the Idaho legislature singled out a discrete and insular minority for a detrimental effect, but didn't do so for heterosexual activity? And the second part to that is that defining sexual conduct to include an act of homosexuality would include something as innocuous as same-sex people holding hands.
The Idaho Family Policy Center, who helped draft the law, responded to the news of a lawsuit, writing in a statement, quote, "The schools, churches, and parents who filed the legal challenge today should be embarrassed." They go on to say, quote, "Most of the claims are baseless and easily refuted. As the United States Supreme Court has repeatedly recognized, states have a compelling interest in protecting children from school and library materials that are obscene. Children should never have unfettered access to pornographic materials in taxpayer-funded schools and libraries, but the law does go beyond publicly funded institutions. And that part of the law makes Idaho unique in this realm as other states pass similar laws."
Idaho's is the only one that also reaches into private schools, that reaches into private libraries, and that is a step even deeper into First Amendment jurisprudence that we don't see anywhere else except for Idaho.
So you may be wondering, well, what is a private library? I've never heard of a library where you go get a special membership. What we mean by a private library is a library that books and its content are privately funded, but Brian, it would be available to the public, like the Collister Church.
The Collister Church was an interesting story because they're trying to be more open to the LGBTQ community, and a lot of these books that were brought forth during the passage of this bill, that were brought up in committee hearings and on the House and Senate floors, have to do with LGBTQ themes.
And as we heard from the attorney McKay Cunningham, if you had a book where you had same-sex parents holding hands, that could be challenged and under Idaho law removed or put into an adult-only section. If you had heterosexual parents that were holding hands, that's fine. So there's some inconsistency there in terms of the law. And in terms of what they're looking for in the long run, by the way, they want the entire law thrown out on constitutional grounds. In the meantime, more in the short-term phrase, they want to have some type of a pause before the school year starts in the fall, an injunction. This could get very complicated for schools across Idaho. As we've heard, some have decided to take drastic steps, not because of the $250 fines. That's certainly a challenge.
The damages on top of that.
Yes, they could put a library out of business.
All right. Thank you very much, Joe. A couple weeks until school starts, so we'll see what happens.